Free George Lee III. If a man cannot get a fair trial, the Emancipation Proclamation, the Civil War, and even the plethora of civil rights laws mean very little, as his life can be stolen in an unfair trial. The following is a mock trial depicting many of the unjust actions that took place in the George Lee III case. Your Honor, there was no grand jury indictment. There was absolutely no physical evidence tying Lee to any of the alleged crimes, and there was no probable cause for rape. There were no credible witnesses. Guilty. But Your Honor, the timeline is shown by witness statements shows that the alleged victim reported the alleged assault before the alleged assault allegedly occurred. Guilty. But Your Honor, a prosecution witness described Lee as being a heavy man, weighing more than 260 pounds, and at the time of the assault, Lee was a tall, slim man. Guilty. But Your Honor, another prosecution witness testified he didn't know Lee, but it was later proved that the prosecution witness lied. Guilty. The alleged victim testified that she went to the hospital sometime after the alleged assault. However, she does not know which hospital, she does not know which doctor, she has no paperwork to substantiate this so-called hospital visit, and hospitals are required to report any treatment of any alleged rape victim. There is no police report to show this alleged hospital visit, and there is no evidence of such a visit. Guilty. But Judge, an alleged victim had a written agreement with the prosecution that effectively stated that she would testify that he raped her or she would be charged as a multiple offender. As such, she had extreme motivation to lie. She would have been likely sentenced up to 17 years in jail. This is extreme motivation, coercion to lie. Guilty. 3 out of 4 of the alleged victims are convicted prostitutes and drug addicts with alleged pending convictions or charges at the time of their testimony. And the 4th alleged victim reported the alleged crime before it occurred. Guilty. 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 30 years without the benefit of parole. But Your Honor, the first trial ended in an acquittal of the extortion charge and a hung jury on other charges. The jury voted 9-3 to acquit. The second trial ended in a mistrial where one assistant district attorney was charged with withholding evidence. The district attorney. The third trial ended in a mistrial where a different assistant district attorney was charged with planting evidence. And the fourth trial mysteriously, and I say mysteriously, ended in a unanimous conviction on all charges, even though there was no grand jury indictment, no physical evidence, and no credible witnesses. How could this possibly be? Guilty. I'm the judge. And people, you should recognize that this is New Orleans, where we do wrongful convictions. They are almost a part of our heritage. Here, it has been proven that justice is not only blind, but deaf and dumb. The U.S. Supreme Court has admonished us, but this is the big easy and your rights can easily be stolen in a wrongful conviction. We have done wrongful convictions many times before. You remember the 16-year-old Shareef Cousin that was wrongfully convicted and sentenced to death? Remember J.T. Thompson? 19 years in jail, wrongful conviction. Remember Daniel Bright, Gregory Bright, Roland Gibson, Larry Hudson, Isaac Napper, Curtis Kyles, Dwight LeBron, Earl Truvia, Calvin Williams, Hayes Williams, and probably many more than you will ever know. So what makes Lee any better than the others whose lives and families were destroyed in wrongful convictions? Now, even though this was a mock trial of the George Lee III conviction, the case and evidence shown were real. Wrongful convictions are no joke. Many people have been wrongfully convicted by an overzealous or almost criminal criminal justice system in New Orleans. The following has been reported in the New York Times regarding remarks the U.S. Supreme Court and others have made associated with the apparent wrongdoings of the New Orleans District Attorney's Office. In 1995, U.S. Supreme Court justices admonished Harry Connick Sr., Orleans Parish District Attorney. Justice John Paul Stevens called the office's violations blatant and repeated. 2007, Harry Connick Sr. testified that he saw no need to change the office's policies after the 1995 warning by the U.S. Supreme Court. Justice Ruth Bader Ginsburg stated that misperception and disregard of Brady's disclosure requirements were pervasive and thus indicative of more than just a rogue prosecutor. Former employees of Mr. Connick have said that the office under his tenure maintained a win-at-all-cost approach and a restrictive attitude toward its obligations to hand evidence to the defense. District Attorney Eddie Jordan, the successor to Connick, stated that the Connick administration had a policy of keeping away as much information as possible from the defense. Justice Kagan said that she could not understand why the Orleans Parish District Attorney's Office persisted in defending its conduct. Justice Sotomayor stated, "It is disconcerting to me that when I asked you the question directly, should this material have been turned over, you gave an absolute no. That's really troubling." Justice Sotomayor made a broader point about the office, which has repeatedly been found to have violated Brady v. Maryland, the 1963 Supreme Court decision that requires prosecutors to turn over favorable evidence to the defense. Now, actions described in the aforementioned articles that were published in the New York Times in November 2011 are tantamount to the things that occurred in the George Lee III case. However, many more egregious actions took place in this mockery of justice called the George Lee III case. Stop unfair trials. Stop wrongful convictions in New Orleans. If a man cannot get a fair trial, the Emancipation Proclamation, the Civil War, and even a plethora of civil rights laws mean very little, as his life can be stolen in an unfair trial. Get involved. Contact the U.S. Attorney General Eric Holder at 202-514-2001 and make Washington, D.C. aware of your dissatisfaction with the New Orleans criminal injustice system. That's 202-514-2001. Request a federal investigation of the George Lee III case. Stay tuned for further information regarding the George Lee III case and other wrongful convictions. Should your cause and other planned actions not move New Orleans to a fair position, additional legal actions are being considered. It has been demonstrated that the New Orleans justice system does not understand fundamental fairness, but it will understand economics. Future possible actions include a boycott of the 2013 Super Bowl and an additional worldwide boycott of the New Orleans tourist industry, going well past the 2013 Super Bowl. Hopefully, your cause will eliminate the need for these extreme measures. We can no longer stand by idly while lives of our people are stolen through unjust actions and an unjust system. Remember, this could very easily have been one of your loved ones. Free George Lee III. You can contact us at freegeorgelee3@gmail.com. Free George Lee III. Thank you.